Hello, everyone. Welcome to SEC Roundup. I'm Tom Zaccaro, one of the founders of ICAN. With me today, as always, is the other co-founder of ICAN, Nick Morgan. Hi, Nick.
Hey, Tom.
And we have a very special guest today. Delighted to introduce Jacob Frenkel. Jacob, good to see you.
And you, Tom, and you, Nick. Great to see both of you as well.
Jacob is probably one of the most distinguished members of the SEC Alumni Defense Bar, and we're going to talk to Jake today about a recent victory he had with the commission on a very unusual case, a trading suspension for Nano Magic. So, Jacob, do you want to jump in and just talk a little bit about?
Let me just set up a little bit for Jacob, give a little bit of background so he can get into the facts. This story that Jacob's going to tell has sort of three parts, and the current part, which we'll get to, which just happened, is Jacob's pursuit of payment of attorney's fees for his client. But to understand why the SEC should be paying attorney's fees, you got to back up and hear the first two parts of the story. Starts during the early days of COVID, when a client of his, Nano Magic, was had its trading suspended by the SEC, which for anyone in the public company space knows a trading suspension is a potential death knell for a company. It's a big deal. That's part one of the story, which Jacob will get into. Then Jacob came in to fight that trading suspension, and as you alluded, Tom, had a pretty remarkable result years afterward, coming out of the SEC in fall of last year, 2024, which then brings us to part three, which is the pursuit of attorney's fees under the Equal Access to Justice Act. So sorry, but I wanted to give a little background before Jacob jumped in.
Well, Nick, thanks for setting the stage, and actually, what makes the result, which I'm grateful, really remarkable, is in the history of SEC litigation of trading suspensions, because there certainly have been challenges to trading suspensions over the years. This is the first time the commission ever vacated, set aside a trading suspension. So it really, I appreciate the opportunity to talk to you about it, but it really was unique in that regard. And I think in even one of the pleadings, one of my arguments was not only do the merits justify setting it aside, but this gives you, the commission, the opportunity to say and hold up this case. We've actually done it now once before, because that's how compelling the case was. Well, now they can do that in the future for trading suspension, say we've actually set one aside. But but to your point, Nick, about the story, this was one of the COVID trading suspensions. I think that SEC actually got, during the first 3 months of COVID or 4 months of COVID, well over 40 or 50 trading suspensions. And this is a company that has been around for 25, 30 years. And they really had developed a solution that basically a surface cleaner that they described as essentially being something that could help with deterring the spread of COVID. They weren't making any crazy representations, and there was talk about the company on a chat board. Well, some of those are sufficient indicators for the SEC. And what I allege is that the Philadelphia regional office, one of the regional offices of the SEC, basically just rushed this through, and that there really was no, you talk about letting down the guardrails. I mean, there were no guardrails. I've got to believe there was no quality review of this, and it was just pushed right through. But the short of what happened was, the SEC did suspend trading. The order was entered in the end of April of 2020. So the company then had 10 days to oppose the trading suspension, ask to have it set aside. And thankfully for them, because I think, sometimes you talk about what's the lesson for a company. There are a lot of companies that are like deer in headlights. trading suspended. What do we do? Was suspended. What do we do? What do we do? And now 2-3 weeks later, well, what can we do now? It's like, well, you missed your opportunity. This company retained me within 24, 36 hours. Went right to work within 5 days. I had a 30-page petition filed to set it aside, where normally it's sort of like there's a little bit of a narrative, and then the SEC sets a full briefing schedule where you would then file an opening brief, the commission would respond, and then you'd file a reply brief. I took the position when they issued the scheduling order, I took the position that we've given you a 30-page opening brief. We want this decision within 10 days. We want it set aside within that 10-day window. And in fact, when they set a briefing schedule that's set to the end of May, which if you think about it, to have the entire matter briefed within 1 month itself is incredible. When they set that schedule, I filed within 3 hours a motion to compress that schedule into the 10 days, saying they know what their case is, make them file by Monday. We'll basically stay up all night and respond. And it went from there. They, of course, didn't react to that. So we then went into into the full briefing schedule. And as part of that, the SEC is required to provide to me as defense counsel all of the facts that were pending before the commission, so that I would actually have a target to shoot at. In fact, I think I used the analogy at some point, and I'll explain why. It'll be obvious in a moment, that it was almost like they blindfolded me in a dark room with a piñata. And the reason for that was in that declaration, they said, in substance, this is the information that we gave to the commission. At which point, you, Nick, you, Tom, I, as alumni of the commission, said, that's not what the statute says. You have to give me all the facts.
Don't tell me in substance.
Don't tell me, you're right, exactly. Don't tell me in substance. I want all the facts. So I basically then argued to the commission, filed a motion, and give me the submission that the staff made to the SEC in order for the commission to decide to impose the trading suspension. The staff pushed back, saying, we don't have to do that. I argued, this is unique. This is not that typical case that the three of us as SEC enforcement defense lawyers and our colleagues in the bar know that when you ask for that memo in the context of an enforcement case, the case law is clear, you don't get it, because it's basically a lawyer's advice to the client. My argument here is different. This is not an enforcement action. This is a commission administrative action that the commission acknowledges is not an enforcement action. So I'm entitled to it. Well, guess what? The SEC didn't do anything about it. So now I am briefing it in the blind, but making all the arguments for the company. Fast forward 2 years, I go to, because I mean, there are a couple of points where I write to the commission saying, where are you? We want a ruling. We're entitled to a ruling. And we had a lot of motions practiced back and forth along the way, because every time I asked for a ruling, the commission came up with some reason to say, what makes you think you're entitled to one? At one point it's like, tell us how you've been harmed. It's like, a couple of years later, you're asking me how we've been harmed when the stock has not resumed trading, even though it was only for 10 days. So
yeah, Jacob, how long was the trading suspension in place?
Well, the trading suspension by law it can only be for 10 days.
Yeah.
In fact, there's a United States Supreme Court case that goes back many years, that basically says it can only be for 10 days, because where the commission has tried to extend it, the statute's really clear. It can only be done, believe it or not, on order of the president. I mean, it's really that extreme. But so it was a 10-day trading suspension, but now you have a company that gets, that's on the over-the-counter market.
Yeah.
It gets what's called the skull and crossbones. So now it's not trading on the over-the-counter market. The effect of the trading suspension, without getting into SEC statutes, rules, and granularity, is there's something called, I'll give you really short, the piggyback exemption, which means that as long as there's a continuous quote for a stock, which is very important for these small cap stocks, for 4 days, then it can, then it can continue to have that quotation traded. Well, the effect of the trading suspension of these small cap stocks is it cuts off the piggyback exemption. That's why I want it set aside, because otherwise they have to start the entire process of being eligible for quotation from the start all over again. So going back into 2 years in, where there's no ruling yet, I've been pushing at the commission to rule. I go to the United States Court of Appeals that oversees the SEC principally, which is the District of Columbia Circuit, and ask the Court of Appeals to order the SEC to rule, because that's all I can ask for. Order it to rule. And in the briefing, the SEC said, "Oh, well, we're about to get to this." So the DC Circuit said, "Well, the SEC said they're going to rule soon, so we're going to dismiss your mandamus. Come back to us if they don't."
And it's already been, just to interrupt, it's already been 2.5 years. So soon means who knows what, 2.5 more years.
Well, it's been 2 years. So it's like you're hoping you could take the general counsel's office at its word that's actually being considered at the commission. Well, ends up being, total of 4.5 years by the time we're finished. So during that period, which is where it got really, really interesting, and which is why I even referenced, the request to compel the commission to turn over the action memo, the facts that were in front of the commission. The commission ordered what I think the commission didn't realize was not a benign and insignificant order. The commission issued an order that simply said, you asked for all the facts before you. There were only 4 minor incidental facts. Here they are. Now you've got it. This whole, that motion is now moot. Well, what the commission did not realize, I really believe had they known this, there's no way they would have issued that order. One of the facts that they included was that a director of the company had traded stock during this activity on the chat boards. In fact, that director did not trade stock. It just so happened he and his brother had the same first initial. The brother did not, the brother did trade, but he had no involvement with the company. And it was a small amount that he traded. Well, at that point, I just, opened the guns and started advancing the position that the SEC staff lied to the commission in order to get the order, in order to get the trading suspension. So I asked for the order. I asked for the action memo again. Of course, I didn't get it. And then fast forward, another couple of years, literally another couple of years. And at some point through this process, the commission issues a new order that basically says, tell us why this is not moot anymore because the company is trading. It's like you've done all this damage to the company, and now you want to know why this is not moot. We're entitled to an order. And I'm thinking, I want an order because I want to be able to go back up to the Court of Appeals when you rule against me, since you've never set one of these aside before. I want to be armed with how bad your record is and have the Court of Appeals just hammer you. That's what I was really anticipating. Well, to my surprise, the SEC Enforcement Division, the Philadelphia office, said, we want a ruling too. Well, they were shocked. I was shocked also. But the end result was in October of 2024, which is literally, keeping in mind that trading suspension was entered April 30, 2020. October 10, 2024, the SEC issues an order that vacated, meaning set aside the trading suspension in its entirety. And they did it what's called nunc pro tunc. It's a Latin term that basically means back to the original point as if it had never been entered in the first place, which obviously we were thrilled.
Your client was still subject to the trading suspension all that time.
Well, again, the trading suspension, in fairness, the trading suspension, expired after 10 days. And, and we, in some of our pleadings that followed it, we were saying, yes, companies been trying to raise money. The company's been trying to get back on the market.
Yeah.
And the stigma of this trading suspension, the stigma from, the over-the-counter market having put the skull and crossbones on, no broker-dealer wanted to resume publishing quotations for the stock. So
Where was it trading? Where was it trading before the trading suspension?
it was on the, if I'm remembering correctly, I don't remember if it was off the top of my head if it was on NASDAQ or in the highest tier of the over the counter market.
Yeah.
But it was, I think it was on the over the counter market. It was getting ready to uplist again or re-uplist to NASDAQ. But again, I could it's only been 4.5 years for that detail. So I don't remember that one with that level of specificity. But again, the company did resume trading because again, when the issue came up in early, I think it was in early 2024, where they said, "Why is this not moot?" Because you are trading again. My whole argument was, you've done all this damage.
Yeah.
We want an order, and now that we've won and really vindicated the company entirely, is like, okay, that's the start now of phase 2, which is now give us the attorney's fees for the damage you did.
Can I, before you go to the attorney's fees issue, let me just pause to emphasize what you already said, which is the thing that the commission did, recognize that the trading suspension should never have been entered. That's pretty remarkable. The SEC makes mistakes, as we all do. Few of them are a result of the staff lying to the commission to cause that mistake. But so getting that recognition from the SEC is a remarkable thing. Tell us now about your pursuit of attorney's fees, which is also unusual. I'm just going to preview this a little bit to highlight how unusual it is. You're proceeding under a statute called the Equal Access to Justice Act, EJA, E-A-J-A. I just looked at, there's a report that comes out every year that reports all the federal agencies that had to pay out EJA claims in each of the last 5 fiscal years. All kinds of agencies, Social Security, FTC was in there, CFPB. The SEC does not appear once in the last 5 years. I understand you have another case that might appear in this year, but so how is it that you're pursuing these fees, and why is your case different, you think?
Well, I mean, it really is unique, and the short answer is I had the good fortune of prevailing in the United States Court of Appeals against the SEC in the First Circuit, not District of Columbia Circuit. I think that was we won at the end of 2023, and then filed an EJA petition in the Court of Appeals. This is a different case, and actually settled, but collected funds from the SEC for attorney's fees early in 2024 in a different case. And again, I don't know if we can actually say what that number was, but at the same time, it's all subject to FOIA, the Freedom of Information Act. So I'm surprised the SEC did not disclose that, because it paid well over 3 times its original offer of a settlement. Didn't get everything we asked for, but at the same time, there's risk, and these are things that you settle. But here, we're basically going for it all. And what makes the statute unique is the statute actually sets a rate, which is a maximum rate for recovery based on hours and other criteria. What we're arguing is that the egregious the conduct of the SEC Enforcement Division staff to get this trading suspension, which such that we are entitled to what's called a special factor enhancement. So don't give us the statutory rate. We're asking for professional fees, all of them, that are relevant to all aspects of the case, all the costs, which include legal research. We're asking the SEC to award us $570,000. And by our having won the case, and that's an important point, that makes us eligible for the award. Why do I say that? It's not like, hey, great, we won. But, you, Nick, you, Tom, we've all been in a situation where we've been successful in getting the SEC to walk away from an investigation. Walking away from an investigation is not a win for purposes of the statute. You actually have to win an adversarial proceeding to be able to be eligible for an EJA award. And we got a decision on the merits. And we're arguing that the government's position was not substantially justified. So we're arguing all of the criteria why we are entitled to a full award. What I'm describing to you is a document that is available on the SEC's public docket. And we have filed our detailed opening brief because there really was no, in my opinion, clear guidance as to how the SEC was going to react, if they were to file a response, whether the commission was going to rule on our petition without any submission. So we basically put it all in the first round, and we now have a briefing schedule where the SEC will file a response, which I will probably argue, no matter what they say, that if you accept the SEC's position, what you're basically saying is you are blessing the notion that it's okay for the SEC staff to lie to the commission and get a trading suspension. So I already know what I'm going to say, and I think I've said that already, in some of my briefs. So, obviously we're a few months away from knowing how this is going to play out. But yes, there is a statute. Thankfully, I've been successful with that statute once before, and now taking a crack directly at the commission, for an award in this case.
A two-peat.
Two-peat, I'll take it. As you said, not many have the one-peat. So I'll and now I'm going for a two-peat. So it's great, and in all candor, I mean, it's sort of humbling, and that is that our colleagues in the enforcement bar are following this with great interest because of how unique this case is.
Do you think the change in the commission will affect you at all?
There's really no way of knowing. Again, on one hand, I do think this is going to be and I know we're not here to talk about the politics of the commission. I do think this is going to be a more thoughtful commission, one that is not just going to make rash decisions, in terms of cases that are brought. But at the same time, they're stuck with the legacy of this decision. So, I'm not going to pull any punches. My hope is that this commission will recognize, or the administrative law judge will recognize, it needs to do the right thing. But the other thing I think that's really important here that, that sort of gets lost as we talk about what we were able to accomplish as attorneys is that it also required a client that was willing to go the distance. I mean, I also sued the Public Company Accounting Oversight Board, the PCAOB, earlier this year, and was, we dismissed the case because the PCAOB shut down that investigation. Same thing there. A client who was willing to, take a deep breath, recognize there's a fight to be had, and was willing to take that fight. I mean, how many times have the three of us in our careers, wished that a client would do that, and they said, no, we just want to fold our tent and walk away. I was thrilled that Nano Magic, was willing to take up the fight and let us take it to a great result.
Well, congratulations and good luck.
You.
A big check from the SEC.
I'm hoping so. So is the client, but everything as part of the vindication process is really what the goal is here. And I won't say that that's the only thing that we're contemplating, but if there are other avenues for recovery, we're still looking into those. We're well within other statutes of limitations.
Well, good. That's great. Congratulations and good luck.
Thank you.
Well, with that, we'll conclude this SEC Roundup. Jacob, wonderful to have you. Thank you for telling us all about your success with the SEC. Nick, be well. See you at the next SEC Roundup. And thank you, and we'll see everyone back at our next SEC Roundup.
And thank you both, and for the opportunity to to share this with you on SEC Roundup.
Thanks.